Chapter 12, Provisional Relief-Injunction-Receiver-Arrest, SS 184, Provisional Relief. In view of the class of debtors and alleged purchasers with whom creditors are called upon to litigate, it is perhaps needless to recall the great importance of prompt and efficient provisional remedies easily accessible to complainants. The defendants may be contemplating flight, or may be engaged in wasting or converting the property with a view of thwarting the creditor's proceedings. The relief afforded by final decree will perhaps come too late to be practically effectual. In some instances, an order of arrest may be procured against the person of the debtor, or of his co-conspirators. In others, an injunction may issue restraining any misuse, encumbrance, or disposition of the property claimed to have been covetously alienated, while in others a receiver may be appointed to take possession and care of the property pending the litigation. Indeed, the appointment of a receiver in a creditor's suit is almost a matter of course. A receiver may even be appointed before answer filed in an urgent case, or before judgment, but only when it is manifest that the fund is in danger of being lost. The receivership will be denied when it does not distinctly appear that there is any property to be preserved. SS 185. Injunction, when allowed, as has been elsewhere shown. The courts will not ordinarily interfere by injunction or otherwise, at the instance of a contract creditor, to restrain the debtor's control over his business or any disposition of his property. Hyde v. Ellery is an exception to the usual rule, additional to those heretofore noticed. It appeared in that case that the debtor had, by fraudulent means, purchased a large quantity of goods from various merchants upon credit, and had sold the goods at auction so that it was practically impossible to trace them. An injunction was allowed in favor of simple contract creditors, upon the theory that its issuance would prevent a multiplicity of suits, and furthermore, because, as the relief sought was to set aside a transaction entered into with the intention to defraud creditors, an injunction was necessary as ancillary to that relief. In another case which arose in Pennsylvania, it was decided that a fraudulent severance of fixtures, made with a design to defeat the lien of a judgment, could be restrained in equity. In suits to annul fraudulent transfers, relief by injunction is often indispensable. Thus, where the petition alleged that an action was pending by plaintiff against one of the defendants, in which certain real estate, which had previously been fraudulently conveyed to another defendant, was attached, and the defendants were about to dispose of such real estate for the purpose of defeating plaintiff's claim, it was decided that a temporary injunction restraining such sale was properly continued to the final hearing, notwithstanding the filing of an answer denying all fraudulent intent. In a case in which the bill charged that the defendant, who was a trustee under an assignment for creditors, was a notoriously bad character, and had refused to allow an inventory of the assigned property to be made, and hence, if loss resulted, the creditors would be unable to show the extent of it, the court held that it was justified in granting an injunction and appointing a receiver without notice. And where a suit was brought by creditors of a deceased debtor to reach property fraudulently alienated by him in his lifetime, it was decided that pending the suit the court properly enjoined the defendant from encumbering or conveying the land. So an injunction may issue to stay waste. It may be observed that a denial in the defendant's answer that he has any property does not constitute a cause for dissolving an injunction restraining him from assigning or disposing of his property. SS 186. When injunction refused, an injunction will not be issued unless facts are shown from which its issuance appears to be a necessity in order to save the creditor's rights, and to prevent the wasting of the subject matter of which he is in pursuit. Thus, in Portland Building Association v. Creamer, it appeared that a creditor's bill was filed to set aside as fraudulent a conveyance of lands about one half of which was woodland. The court held that an injunction which restrained the grantee from cutting and removing the timber from the premises would not be continued, it being shown that the value of the land, without the timber, was ample to satisfy the creditor's claim in case the conveyance should ultimately be annulled. SS 187. Receiver in contests over real property. Where real property is fraudulently transferred, the court, as we have seen, may adjudge and direct a transfer to a receiver. Vaz v. Woods is an illustration of the disinclination of the court to interfere by the appointment of a receiver of real property, where the party in possession has what purports to be the legal title. The case came up on appeal from an order appointing a receiver upon a creditor's bill to take possession of the property alleged to have been conveyed in fraud of the plaintiff. Simrall, J. Said p. 128. As against the legal title, The interposition is with reluctance. It will only be done in case of fraud clearly proved and danger to the property. Provisional relief is not encouraged in land cases because the subject matter of contention is immovable, practically indestructible, and unlike personalty cannot be spirited away. In New York, a receiver will not be appointed in ejectment before judgment. This practice has been a subject of criticism. The rule is otherwise in an equitable action to annul a conveyance of real property, even though it is conceded that ejectment could have been brought in the place of the equitable action. But even in such cases, the relief is not easily secured. SS 188. Receivers of various interests on supplementary proceedings under the Wisconsin Code to enforce a decree for alimony. The court may appoint a receiver to take possession of the effects of the defendant in the divorce proceedings. The sheriff's return of the execution is sufficient ground therefor, and the receiver thus appointed may attack a fraudulent conveyance of the debtor's real estate made with intent to defeat the decree for alimony. A receiver has been appointed of crops growing on a plantation, and in a case where an annuity, which was changed upon real property, was in arrear, and also of a living. SS 189. Title on death of receiver, where a receiver of a debtor's property has been appointed, and the debtor has executed the usual assignment of the property to him. Upon the death of the receiver, the title to the property vests in the court. The receiver's possession is the court's possession, and he is merely its agent or representative. The functions of the receiver continue after the death of the appointee, and it is competent for the court to appoint a successor to conduct and complete the litigation, and in other respects fulfill the duties which the first receiver left incomplete. Nor is it necessary that the defendants in the suit should be given notice of proceedings for the appointment of a successor to the first receiver. SS 190. Removal and dismissal of receiver. The jurisdiction of a court of equity, says Mr. High, which is exercised in the removal of receivers, bears a striking resemblance to that which is called into action upon the dissolution of an interlocutory injunction, and in both cases the power to terminate seems to flow naturally and as a necessary sequence from the power to create, and as an interlocutory injunction is usually dissolved upon the coming in of defendant's answer, denying under oath the allegations of the bill. So in the case of a receivership, if the answer under oath fully and satisfactorily denies the equities of the bill or the material allegations upon which the appointment was made, and these allegations are not sustained by any testimony in the case, the order of appointment will be reversed and the receiver removed. It is said that the high prerogative act of taking property out of the hands of a party and putting it in pound ought not to be exercised except to prevent manifest wrong imminently impending, and when the court, upon the coming in of the answer, discovers that the danger is not imminent, and that there is no pressing necessity for the order, it may be revoked or modified on such terms as the court thinks wise. We may here state that it is not a sufficient cause for removing a receiver of a judgment debtor that he has employed the debtor as an agent to assist in collecting the assets, the receiver being solvent and the trust otherwise properly executed. In many cases, the debtor's knowledge of the business peculiarly qualifies him to render valuable services to the receiver, and the receiver should be served with notice and a specification of the grounds upon which the removal is sought. It may also be observed that where the order appointing a receiver was fraudulently procured and was subsequently annulled, the receiver will be required to account for the fund intact and will not be allowed any deductions. SS 191. Arrest of defendant. In New York, to authorize the arrest of a defendant in an action for alleged fraudulent disposition of his property, actual intent to defraud must be clearly established. Proof must be adduced of an actual and guilty intent to defraud creditors. A mere constructive fraud such as the law implies because an act is done in violation of the statute or of the rights of the creditors at common law is not sufficient. Hence an order of arrest against a partner who, with knowledge of the insolvency of the firm, paid individual debts with firm assets, was vacated. Where there is no evidence of guilty knowledge, the debtor should not be subjected to arrest for acts of constructive fraud. The lex fori, as we have seen, governs in cases involving the question of the right of arrest.